Deputy Public Defender Oscar B. Rowe, with a lesson on criminal solicitation, California Penal Code 653F. The elements of this crime are detailed in the jury instructions Cal Crim 441. To prove that the defendant is guilty of this crime, the people must prove that 1. The defendant requested another person to commit or join in the commission of a specified criminal offense, and 2. The defendant intended that the crime be committed, and, when appropriate, 3. The other person received the communication containing the request. To decide whether the defendant intended that the person commit the offense, the court will provide separate instructions the alleged crime. The crime of solicitation must be proved by the testimony of at least one witness and corroborating evidence. Or, the crime of solicitation must be proved by the testimony of at least two witnesses without corroborating evidence. Corroborating evidence is evidence that tends to connect the defendant with the commission of the crime and is independent of the evidence given by the witness who testified about the solicitation, or independent of the facts testified to by that witness. Corroborating evidence need not be strong, or even enough to establish each element by itself. Corroborating evidence may include the defendant's acts, statements, or conduct, or any other circumstance that tends to connect them to the crime. A person is guilty of solicitation, even if the crime solicited is not completed or even started. The person solicited does not have to agree to commit the crime. If the jury finds the defendant guilty of solicitation, they must decide how many crimes they solicited. When deciding this question, consider the following factors. 1. Were the crimes solicited part of a plan with a single objective or motive, or did each crime solicited have a different objective or motive? 2. Were the crimes solicited to be committed at the same time? 3. Were the crimes solicited to be committed in the same place? 4. Were the crimes solicited to be committed in the same way? 5. Was the payment, if any, for the crimes solicited one amount, or were different amounts solicited for each crime? The jury will consider all of these factors when deciding whether the defendant's alleged acts were a single crime or separate crimes of solicitation. One court has held that the person solicited must actually receive the solicitous communication. People v. Safon, 2000. In Safon, the defendant mailed a letter from prison containing a solicitation to harm the fetus of his girlfriend. The letter was intercepted by prison authorities and thus never received by the intended person. If there is an issue over whether the intended person actually received the communication, the court will give the element 3 instruction. Other words for solicit include to ask, entreat, implore, importune, to make petition to plead for, to try to obtain, or to offer or invite another to commit a crime. People v. Gordon, 1975. The solicitation of a person in California to commit a felony outside the state constitutes solicitation. People v. Burt, 1955. When defining the crime of murder, in the case of a solicitation of murder, the trial court must not instruct on implied malice as an element of murder. Because the crime of solicitation to commit murder occurs when the solicitor purposely seeks to have someone killed and tries to engage someone to do the killing, the person must have express malice to be guilty of the solicitation. People v. Botger, 1983. I'm Deputy Public Defender Oscar B. Rowe, and that is our lesson on criminal solicitation, California Penal Code 653F.